So where did we get the idea of individual rights? Do I even need to answer that question by now? From the Catholic Church, believe it or not. We're going to talk about that and a lot more today on the Catholic Church, Builder of Civilization. Welcome to the Catholic Church, Builder of Civilization. I'm Thomas Woods. In all the episodes up through today, we've been talking about aspects of Western civilization that are indebted to the Catholic Church. And yet, most people know nothing about this. So it's time we rectify that. Now today, I've got something else interesting for you that I think most people don't know about and they're not taught in school. But what was the first modern legal system in Europe? Guess what? It wasn't English common law, it was the canon law of the Catholic Church. Because for the first time, you had a single systematic body of law. Canon law, of course, the Church's law, became a model for the emerging states of Western Europe. Because what in fact happened is that the Church's law had never really, until about the 12th century, had never been collected into a single source. It was scattered everywhere. If you wanted to find church law, there was no book you could go to. You would find aspects of church law in the Bible, in the church fathers, in local councils, ecumenical councils, papal statements, whatever. But there was no systematic source that you could consult. And that came to an end in the year 1140, when a man named Gratian wrote the Concordance of Discordant Canons. And this work brought together and synthesized all these various sources of the Church's law, and brought them together and made them into a single coherent whole. And in effect, by doing that, Gratian showed the Western world how you put together a legal system, how you take disparate elements that are scattered and you bring them together into a single whole that makes sense. Now, this is not always so easy, because when you have so many sources of law, it's not surprising that sometimes you find contradictions. One source says you should do A, another source says you should do B. When you're bringing the law all together, how do you resolve that? Should you do A or B? And what Gratian and other canon lawyers showed is that you use the idea of natural law to arbitrate between these two alternatives. So, in other words, the idea of natural law is that there are certain principles, even before human beings write up any law, there are certain principles that we know to be right, that we know to be wrong, because they are written on our hearts, as we learn in the Bible. So the natural law becomes the way you decide, is this the rule we should abide by, or is this rule? Natural law can help you adjudicate that. Well, the countries of Western Europe, as they were coming out of the feudal period of Europe, they had totally scattered legal systems too. They had this kind of law, that kind of law, all kinds of directives all over the place, and no coherence. So when they went to put together a modern legal system, what did they consult as a model? The canon law of the Catholic Church. Don't you think that's kind of interesting? Well, it's not just the structure of the canon law that's important. It's not simply that it showed people how to take a lot of different sources and put them together into one code of law. That's important. But it's also the content of canon law that matters. It's also some of the things that canon law taught rubbed off on law in general. For instance, the Church had jurisdiction over marriage in the Middle Ages, and the canon law of marriage held that a valid marriage involves the free and informed consent of both the man and the woman. So you can't force people to get married, you can't get them drunk and then get them married, you need to have their free and informed consent. Well, what does that mean? Well, in fact, Harold Berman, who's probably the greatest historian of law in the Western tradition by far, he's a 20th century historian, Harold Berman says that right here in the Church's canon law of marriage, emphasizing consent as the heart of the marriage bond. He says here were the foundations not only of the modern law of marriage, but also of certain basic elements of modern contract law, namely the concept of free will, that you have to enter into a contract freely the same way you do in a marriage. We also see, he says, the related concepts of mistake, duress, and fraud, because the Church's canon law of marriage also told us that if people have made a mistake about the identity or some important quality of their putative spouse, that the marriage is also not valid. So these are basic aspects of all contract law, and yet here they are deriving from the canon law of marriage, not particularly well known. What's also important is that it was very common, the practice of what we might call infant marriage in Western Europe. This was a barbarian custom, and infant marriage, of course, is incompatible with the Church's canon law of marriage, because how can an infant give his consent to a marriage? So it was with the implementation of the canon law of marriage that the barbarian custom of infant marriage was abolished altogether. Now, one of my favorite aspects of all this is that the Church's canon law, coming into being in a systematic way in the 12th century, for the first time is now bringing into Western European practice, for the first time since the barbarian invasions, a clear emphasis on the importance of rational trial procedures. Now, what do I mean by that? Typically, in barbarian modes of law, reason was not employed to determine who was guilty and who was innocent. Rather, magical modes of determining guilt or innocence were used, modes of ordeal. So, for instance, one barbarian method of determining whether you were guilty or innocent consists of what we might call the ordeal by hot water. And here you'd take the accused person and you'd bring him over to a cauldron in which boiling water had at the bottom a stone. And it was required of the accused to reach into that scalding water and pull the stone out. Then they would bandage his arm, because of course it's scalding water and his arm's not doing too well at this point. Then they'd wait 3 days. When they take off the bandages, if he has begun to scab up on his arm, then that means he's innocent. But if he hasn't yet started to scab up, that is indication of his guilt. Well, who wants to be subject to this kind of procedure? This is exactly the kind of thing that the rational trial procedures emphasized in canon law helps to bring to an end. Now, another barbarian method of determining guilt or innocence is the ordeal by cold water. Well, that sounds fine. Cold water, refreshing, right? Well, the ordeal by cold water consisted of tying a person's hands together and his feet together and throwing him in the river, and then observing to see whether he sinks or floats. Now, in many versions of the ordeal by cold water, if you float, that is indication of your guilt. You might think that floating would mean you're pure, like ivory soap, you're 99.44% pure, but to the contrary, the thinking was that perhaps the divine principle in the water is trying to eject you by not allowing you to sink. So that's an indication of your guilt. Well, again, nobody would want to live under that system. And in fact, that system doesn't really tell us who's guilty, who's innocent. It just tries to end the dispute. Look, this is how it turned out for this guy. He floated. That's the end of it. Let's just stop the fight right here. Instead of pursuing justice, barbarian law simply tried to stop feuding and fighting by just coming up with some kind of an answer, even though it was a totally arbitrary answer, whether the guy floats, whether his arm scabs up. This is exactly what canon law was opposed to. So, canon law, the first modern legal system in Western Europe. But there's much more to be said about the Church's contributions here, because as long as we're speaking about law, we can speak about the concept of rights. That I have a right to life. I have a right to own property. I have a right to enter into a contract or enter into a marriage. I have the right to defend myself in a court of law. All these things are rights. Where does that idea of rights come from? For a long time,